And let me share with you a case study. Okay, this is a very interesting one. In this case, that I've actually represented a diamond merchant. Okay, the facts of which is very peculiar. A Form Q was actually filed by the client way back in 2013. So it was very proper. They actually filed their Form Q, the notice of appeal, with the IRB at the correct IRB department, acknowledged receipt by the IRB in 2013. Nothing happened since 2013. No hearing was fixed, no notice was given by the special commissioners fixing the hearing before them, But then, strangely, in 2016, the IRB suddenly initiated a recovery court action against this client of ours in 2016. So it became a point, and then, of course, I've earlier shared with you that as far as the law is concerned, a civil suit are normally not winnable. Okay, but in this particular case, very interesting arguments was raised. Basically, it has to do with the failure of the IRB to send the Form Q to the special commissioner course within the 12 months period that they are required to do. Without them sending the Form Q or the notice of appeal to the special commissioners, let's say in 2014, the argument that we have raised is that the taxpayer have been deprived of their right of appeal. And that is a breach of natural justice because their case could not be heard on the merits before the special commissioners. And therefore, it would be oppressive and wrong for the IRB to go after the taxpayer in 2016 to pay the tax. Okay, this became the contentious issue. So of course, what happened is that the IRB then filed in a summary judgment application. We rebutted it, we challenged it, we opposed it by raising this breach of natural justice argument. We then produced the acknowledgement of receipt of the 2013 Form Q. We actually have the acknowledged receipt showing the stamp, the IRB stamp, that particular branch's stamp of acknowledgement. So it was all kept in by the taxpayer. In rebuttal to the affidavit, the IRB actually took the argument that stamp, the acknowledgement stamp, was not theirs. Meaning, they are actually indirectly saying that the stamp had been forged. It's a forgery, right? But they fell short of lodging a police report against our client, because we know for a fact that that stamp was actually is a genuine one. But that was actually what the position that the IRB took. Of course, we will then, because of this triable issue of whether or not the client, the diamond merchant, actually filed an appeal in year 2013 with the IRB, became a triable issue. Then their summary judgment application did not succeed. And the court basically says, okay, this is a tribal issue. I cannot decide whether based on affidavit, because both sides are actually saying different things, and wanted to fix the case for trial. So that's how it happened. And well, the IRB subsequently, because my understanding is that I think they do not want to go for trial and subject to their officers to cross-examination. And then they came back to basically propose that they withdraw the civil suit and then allow our client the extension of time to refile, the so-called extension of time to refile the Form Q with an undertaking and promise from their part to not go after our client in the civil suit until the conclusion of the notice of appeal. So that was what happened, and at the end of the day, for this particular case, again, a revision of the assessment was raised, accepted by the client, and then settlement payment by installment was arranged, and then the matter was sorted out in a way amicably at the end of the day. Okay, so this is the fifth case study I'm sharing.